We continue. The Honourable Minister of Legal and Constitutional Affairs, Marlene Malahoo Fort, recently announced that persons charged with murder and gun offences will be denied bail if the proposed Bail Act is approved. Now, this has left a number of persons up in arms, including local attorneys, describing the move as unconstitutional. Queen's Counsel Peter Champagne joins us now to put things into perspective. Morning, sir. Good to see you as always.
Good morning.
Hope
Good morning. Good morning to your viewers.
Yeah, this is not an either thing, though. I mean, there can be reasons that you don't get bail, and there should be reasons that you get bail, right? So it's not an either, is it?
Well, that is what obtains under the Bail Act currently, which was passed in 2010. But I think, to be fair to the Honourable Minister, I don't think that it was put as emphatic as that, but it led to an insinuation that persons on murder charges and gun charges can't be at large. And that in and of itself, to my mind, is very inappropriate, shall I say, because it feeds into this narrative that the judges are derelict in terms of their duties, in terms of giving bail or when considering bail, and that is simply not so.
Yeah.
Conditions are attached.
Yeah. Just before Sim, God forbid you have to defend me for whatever reason. Yes. What would be a reason that I shouldn't get bail, and what would be the reason that I should get bail?
I mean, apart from your who you are?
Yeah.
There are various conditions that would, or considerations, I should say, that would be taken into consideration. Whether or not you are a flight risk, whether or not if you're offered bail, you will be residing in the same community where the complainants are, whether or not your history is one that you are not unfamiliar with the court system. So there are a number of considerations under the Bail Act. I think it's Section 6 that specifically indicates that a judge can basically take into account any factor that he or she considers to be appropriate in the circumstances. So it's not offered as a matter of course.
Right.
So lots of folks coming out, as Nev said, to denounce the proposal. Some folks calling it unconstitutional, a breach of a defendant's right to due legal process. I'm wondering, because usually when these announcements are made, I hear this uproar. What would inform a position such as this before it is made? Because it almost seems like the announcement is made and then people are punching holes in it, legal holes, loopholes, and so on. You have to kind of wonder if it wasn't informed.
I would want to say that it is partially informed by virtue of the JCF saying that there are a number of persons who, when offered bail, repeat offenses or are known to be involved in criminal activities after bail is granted.
That's what you call the rate of recidivism.
Correct. But the point is that when you look at the majority of cases in which persons are offered bail, that is simply not the case. So, to my mind, it's a knee-jerk reaction to the spate of crime and the rate that it is now. And I think that we are, as always, treating the symptoms and not the cause of the problem. Cause, you need to pay the police officers more money. You need to improve our ability to rely on scientific evidence to make sure that cases that when they come before the court, the only option for persons who are really guilty is to plead guilty. In other jurisdictions, many trials do not go to that extreme. Persons plead guilty. You see it in the United States.
Because you have the irrefutable proof.
Because you have the overwhelming evidence.
But guess what, Sir Peter? We are not there. Are we near there? So what do we do in the interim?
We have made some improvements, because I note, for example, and I think Jamaicans ought to be aware of this, that there is now greater reliance on DNA evidence. A simple thing where you take a gun, police take a gun from the waistband of somebody who doesn't have a license. They don't swab it, they don't fingerprint it to confirm that that person had the gun. Because when you go to court, invariably, sometimes the persons will say who are charged, the officer didn't take it from my waistband. He found it over there and assumed that I was the one who had it because I was in close proximity to it. So we need to focus on things like that.
We had this as a hot topic, and I mentioned that I didn't agree with it, but I said, all right, I'm charged for murder, but then somebody saw me on one of the Jamaica Eye, and they see me fire the gun, and that's a reason for me not to get bail, even though I've not been convicted. Don't?
Yes, because one of the considering factors is the strength of the allegation.
Right.
So if the allegations that come before the court consist of video evidence that is obtained and the image is clear, then that is overwhelming evidence where you could take that into consideration, and you must, and determine that, well, this person is not a fit and proper candidate for bail.
Okay.
Yes.
So again, it's not a...
It is not. It is not. It is
Okay.
not. And I think we need to deal with the issues. And I am particularly offended by virtue of the fact that there seems to be this insatiable appetite from certain quarters wanting to blame the judges, always. And regrettably, our Bar Association, our Advocates Association, the legal fraternity, many of us sit down and don't call it out for what it is.
Blame them for what? Allowing people to go on bail who shouldn't
Spate
be on
of
bail?
crime, the judges. The judges are to be blamed. They acquit too many persons.
Okay.
They give too many bails. It's wrong. It's really wrong.
So we're scapegoating.
Absolutely.
I don't know. I hear what you're saying, but I don't know that the fixes that you mentioned, symptomatic versus core and so on, we have a lot of work to do.
We
So
do.
what is your proposal in the interim, short term to medium term, even as we work on your long term fix, to ensure that there is parity and equity and fairness?
Yes. I think, firstly, we need to enter into some serious discussions with the United States. We don't manufacture guns here.
Correct.
That's number one.
Ding, ding.
Number two, we need to increase, and I'm unpopular for this, but it's a fact. We need to increase the sanction in terms of sentencing for persons found with more than one illegal firearms. This 5 years thing, imprisonment and so on, can't work. You're a dealer. That's what you are.
So you're proposing what?
Stiffer sanctions where that is concerned. So those are just a few of it, of the solution. And also creating incentive for police officers. Link that to meaningful promotion. You have a corporal who is at a station, he finds 3-4 illegal firearms every year. He's still a corporal of police. That doesn't require money. That doesn't require serious thinking. But then again, perhaps it makes too much sense and it will never be implemented.
You speak to the knee-jerk reaction, the spate of crime. It's bad.
It's bad.
It's bad.
It is bad. And I'm not immune. You're not immune from it. So therefore, when we come out and we say these things, it's not self-interest. It is not. We are just there every day. We see what the issues are, and we realize that this is what needs to be done.
So you think the minister's statement or proposal is...
Well, of course.
Is a manifestation of panic?
I think it's a knee-jerk reaction with the greatest of respect to the Honourable Minister. And I think this, in it, is the appetite, the inclination always to blame the judiciary. And it is unfair. It is wrong.
Sim asked the question about how informed the minister might have been, or
Yes.
how informed the minister might not have been.
Yes.
What happens if the lawmakers pass this? What happens?
Very good question, Neville. Well, I think we can take some guidance from Trinidad and Tobago. In the case of Akili Charles, which was heard in February of this year, the Chief Justice and 2 other judges ruled that not offering bail to persons on murder charge was wrong. It offended the principles in a free and democratic society. So that was a case where they went that route, where their Bail Act, Section 5.1, I think it is, of that Bail Act, that's categorically denied any offer of bail to persons charged for murder. And the court ruled it as wrong, unconstitutional, and it is now on appeal to the Privy Council.
Wow.
We talk about... Sorry, Nev, Jinx. Go ahead.
Do you think that might happen here?
May, and they would have to look to change the constitution. And in here even, I think it was in 2010, there was a case where you had the 60-day remand, no bail, and that was struck down as well.
Okay.
We talk in this country about justice and truth being ours forever.
Yes.
None them. It's a random question, but how would you rate Jamaica on the justice scale?
In terms of our judges?
In terms of our justice system.
It gets a lot of flack, and I think unfairly so. And I think that we have done extremely well with the meager resources that we have had. We have, this pandemic has brought about a revolutionary system where trials are by way of Zoom sometimes. Not trials, but bail application, mention matters. There is a lot of activities that enhance the system So I don't think that it is as bad as it appears, and I think that when persons serve as jurors, for example, and they experience it, they come away getting a sense that, well, it's not as bad as we thought, you know. It's not as bad at all.
Good to see you.
Okay.
Thanks for those words. Excellent stuff.
Thank you.
Look after yourself and God bless you and your family.
Same to you.
Queen's Counsel, Peter Champagne.